Torts. By leaving the electrical power on to only prevent theft of property on the land, company is indirectly using deadly force to defend against property, e.g. spring gun. When two or more DS cause P's injury and the actions are independent and divisible, meaning possible to identify the portion of injuries caused by each D, then each will be liable only for their identifiable portion. D1 may be liable for both injuries if the second divisible injury was foreseeable. An intermediary's negligent failure to discover a defect is not a superseding cause, and the defendant who supplied the defective product will be held liable along with the intermediary. While the general rule is that a principal is not vicariously liable for the torts of an independent contractor, a broad exception applies when the duty of care is non-delegable on public policy grounds, such as a landowner's duty to make his premises safe. Statements made as part of a judicial proceeding is a defense to civil liability in order to ensure that the witness will testify freely and truthfully without fear of lawsuits. Typically applied in a defamation suit, but can also apply to another tort such as IED. A parent's contributory negligence is not imputed to the child. A spouse's contributory negligence is not imputed to his spouse. Plaintiff need not show physical harm for a claim of IED. IED can be done with intent, KTSC, or recklessness, i.e. substantial disregard. Reckless infliction of emotional distress. Careful inspection of the product is relevant in a negligent products liability action. Inspection is irrelevant in a strict products liability action. For a negligence products liability case, the plaintiff may rely on a residential ipsa loquitur theory. Humiliation is a recognized element of damages for the commission of an intentional tort. An employer may be liable for its own negligent selection if it has some reason to be on notice that the actions that resulted in harm were likely to occur. Consent can be implied from the plaintiff's conduct or from circumstances, e.g. the action was necessary to save the plaintiff's life. However, even if there is consent, a defendant will nevertheless be liable if his actions go substantially beyond the scope of the consent. Therefore, if owner reasonably believed that traveler was the robber, owner's privilege of arrest defense will succeed, and traveler will not prevail in her false imprisonment claim. However, the law does not recognize a claim for emotional distress from negligently caused property loss. Employers, however, can also be found liable for the intentional torts of their employees under a negligence theory, i.e. the employer failed to use reasonable care to protect the victim from such conduct. It is also likely that the harm posed to Adam by this debris and large limbs is greater than whatever utility Bess has in letting nature take its course for a private nuisance claim. Slipping on a banana peel with your crutches will be a foreseeable injury from the negligence of the original tortfeasor who put the plaintiff in crutches. David may assert full indemnity against Mark because David's misconduct was passive negligence whereas Mark's misconduct was an active intentional tort. Therefore, if David fully satisfies the judgment, David then will have a right to recover from Mark indemnity for the full amount of the judgment because Mark was an intentional tortfeasor. While plaintiff is well known among many people in the community because of his job with Kitchen, he is not a public figure because he has not thrust himself to the forefront of a particular public controversy. Privilege of arrest is a defense to false imprisonment. Unconsent person performing surgery on a patient is offensive for the purposes of battery. Parents are not vicariously liable for the torts of their children unless the parents were negligent in allowing the child to engage in tortious conduct. Manufacturers are not strictly liable for unavoidable unsafe products if the danger is apparent and there is no way to make the product safer. A statement is not defamatory if the only reasonable interpretation is intended as a characterization. Governor murder. Physical consequences for negligent infliction of emotional distress are not required for egregious conduct, such as 1. An erroneous report of a relative's death, 2. The mishandling of a relative's corpse. Even when a party is not vicariously liable, that part may be found liable if she was negligent in supervising who committed the tort. The intent for assault can be transferred to a battery. Same for the other intentional torts. Residential ipsa does not apply to Kenko if the workman knocked over the can, denting the can. Cause in fact equals actual cause. Legal cause equals proximate cause. A qualified privilege of defamation will be lost if the defendant knew the job-related statement was false when made or acted in reckless disregard of whether it was true. A person does not have a right of privacy when the street was open to the public and the subject was newsworthy. Two people acting in concert of a dangerous activity such as car racing, both can be found liable for injuries to a pedestrian. A manufacturer may be liable under the rule of apparent agency. In tort cases, punitive damages award are not authorized unless there is proof of willful or wanton conduct by the defendant. A small statistical likelihood is not by itself sufficient to support a finding required for battery liability that the manufacturer acted with intent to cause harmful contact or with knowledge that a harmful contact would occur. Civil procedure. A complaint for fraud has special pleading rules that require a party to state more detail under special circumstances, including claims that assert fraud or mistake. The Interlocutory Appeals Act also may permit a review of an interlocutory order, but it is discretionary and may be available only when the trial judge certifies that the interlocutory order involves a controlling question of law, as to which there is substantial ground for difference of opinion, and immediate appeal from the order may materially advance the ultimate termination of the litigation, and 2. The Court of Appeals then agrees to allow the appeal. The collateral order rule may permit a review if the claim or issue is separable from and collateral to the main suit and is too important to require deferring appellate review. The order then may be classified as a judgment in a separate, collateral, proceeding. Therefore, the specific federal rule of civil procedure will be applied in federal court, Erie, as long as it is consistent with the Rules Enabling Act and is not unconstitutional. Second, voluntary dismissal before D responds equals adjudication on the merits. Judgments are enforceable during post-trial motions unless the otherwise orders and on such conditions for the security of the adverse party as are proper. The court must impose sanctions, movements reasonable expenses, on the party of her attorney for failing to respond to a discovery request and a motion to compel and sanctions with good faith has been sent. A court may relieve a party from final judgment or order based on fraud, misrepresentation, or other misconduct of an adverse party, and such a motion was made within a reasonable time not to exceed 1 year. A party may obtain, without a court order and without showing need and hardship, a copy of any statement or recording previously made by that party. Supplemental jurisdiction may not be used to override the diversity rule. Third-party defendant's claim against the plaintiff is not compulsory. Failure to assert the claim in the pending action will not bar him from asserting it in a separate action. Remember that service may be made as provided by the rules of the state in which the federal court sits or the state in which service is to be effected. When the amount of damages is not for a sum certain, the judge must hold a hearing on damages before it can enter a default judgment. A cross-claim is never compulsory. Consent judgments and settlements generally do not carry with them preclusive effect. Congress may change federal civil statutes to apply those changes in all actions in which a final judgment has not been rendered. An involuntary dismissal with prejudice is a final judgment on the merits for claim preclusion. A part who files a motion for RJML and a new trial, the court should rule on the motion for new trial even though it grants the RJML. You must provide your insurance policy as part of discovery even if not requested. Both the granting of the preliminary injunction and the denial of immunity are immediately appealable. Unlike common law, the federal court does not recognize the physician-patient privilege. Under the full faith and credit clause, courts must give the same effect to a judgment that the court that issued it would. Since the original case was decided in State A, whether it has a preclusive effect or not must be evaluated under the law of State A. Imleader is not proper for alleging that the plaintiff sued the wrong party. That would be motion to dismiss. However, a plaintiff may not remove the case to federal court. A plaintiff could simply file the case in federal court to begin with. Thus, the court will remand the case to state court and will not hear the case. Further, the facts do not state that the earlier served defendant joined in on the notice of removal. For this reason, the plaintiff does have a valid basis for a motion to remand. After a verdict is returned, but before the jury is discharged, the court must on a party's request, or may on its own, poll the jurors individually. If the poll reveals a lack of unanimity or lack of assent by the number of jurors that the party stipulated to, the court may direct the jury to deliberate further or may order a new trial. Unless the parties stipulate otherwise, the verdict must be unanimous and must be returned by a jury of at least 6 members. Under Rule 52(a)(1), when a case is tried to the court, the judge must find the facts specially and state the conclusions of law separately. Federal courts must give full faith and credit to state court judgments by giving a state court judgment the same effect that the rendering state would give it. So if State A does not allow non-mutual issue preclusion, the federal court must give full faith and credit to that effect. Under Rule 38(b), a jury demand is timely if it is made within 14 days after the last pleading directed to the issue for which a jury is sought. Ordinarily, the last pleading directed to a plaintiff's claim is the answer. Therefore, the deadline for a plaintiff to make a jury demand is usually 14 days after the defendant serves the answer. Here, the architect filed a motion to dismiss in lieu of an answer. Because the architect has not yet served an answer, the 14 days have not begun to run, even as to the fraudulent misrepresentation claim in the retailer's original complaint. The Supreme Court held that when both legal and equitable issues are presented in a case, a court must submit the legal issues to the jury first, and then the court can resolve any remaining equitable issues. If any issues overlap, the court is bound by the jury's resolution of the overlapping issues. Defendant must be given at least 7 days written notice before the default judgment hearing when he has previously appeared. Typically, TROs are not among the decisions that are immediately appealable under this statute. Under Federal Rule of Civil Procedure 65, however, a TRO is not to exceed 14 days. If a TRO is extended beyond this time limit, it may be treated as a preliminary injunction, which can be the subject of an interlocutory appeal. Rule 48(b) permits a verdict of a jury of fewer than 6 jurors only if the parties agree to it. A trial judge is not obligated to set forth findings of fact in a written opinion or memorandum of decision, although the judge may do so. Rule 52(a)(1) authorizes trial judges to state their findings of fact on the record. Here, a class action based upon diversity of citizenship jurisdiction is not possible because none of the plaintiffs possessed a claim in excess of $75,000. Claim preclusion prevents a claimant from splitting his cause of action when the claimant loses a judgment. All possible grounds for relief arising out of the same transaction or occurrence are barred in future litigation between the same parties. Because the motorcyclist's personal injury and property damage claims arise out of the same accident, they are part of the same cause of action, and he should have brought them in one action. Minimum contacts requires purposeful availment and foreseeability. A substantial part of where the claim arose can be where the plaintiff bought the widget and where they were injured by the widget. Rule 51(d) expressly preserves plain error review even when a party has failed to preserve an objection to an instruction that was given. When both legal and equitable issues are presented in a case, a court must submit the legal issues to the jury first, and then the court can resolve any remaining equitable issues. Rule 48(b) permits a verdict of a jury fewer than 6 jurors only if the parties agree to it. 2% of its tires distributed in State A does not satisfy continuous, systematic, and substantial contacts standard with State A. The 11th Amendment sovereign immunity does not apply when the United States is suing a state. Membership in an association may not be deemed an endorsement of the illegal activities of the association unless the individual has a specific intent to further those illegal activities. You may still to an error in jury instructions by the judge even after the jury has started deliberating, so long as the inapplicable instructions constituted that affected the party's substantial rights. In order to have a scheduling DER modified, moving party must show good cause. This requires that the party acted diligently in meeting the original deadline. The time limit for a RJ-MOL cannot be extended. A pretrial order may only be amended only to prevent manifest injustice. Evidence. Defendant must be charged with murder, not attempted murder, for dying declaration to apply. The court conduct any hearing on a preliminary question so that the jury cannot hear it if 1. The hearing involves the admissibility of a confession, 2. A defendant in a criminal case is a witness and so requests, or 3. Justice so requires. Where a witness makes a statement not directly relevant to the issues in the case, the rule against impeachment, other than by cross-examination, on a collateral matter applies to bar the opponent from proving the statement untrue either by extrinsic contradictory facts or by a prior inconsistent statement. The purpose of the rule is to avoid the possibility of unfair surprise, confusion of issues, and undue consumption of time. The state court is least likely to take judicial notice of the Australian law. Most state courts will not take judicial notice of the law of a foreign country. Under Federal Rule 803(13), statements of fact concerning personal or family history contained in family Bibles, engravings on tombstones, etc., are admissible, regardless of whether the declarant is available. If the evidence is of a type that is likely to be confused or can be easily tampered with, the proponent of the object must present evidence of chain of custody by showing that the object has been held in a substantially unbroken chain of possession. Marital privilege does not apply in actions between spouses. A witness may refresh their recollection with a written document before trial. Statements made for medical diagnosis may also include source of injury as well as past symptoms and medical history. An expert's opinion may be based on knowledge gained by him at trial. A prior statement that was made under oath may be used for impeachment and substantive evidence. Always ask yourself if the evidence can be admissible for as a hearsay exception or for impeachment. Settlement negotiation rule cannot be used before a disputed claim between the parties arises. After a plea is accepted, it is admissible. Only offers and withdrawn offers apply to the rule. Must also be used against the defendant. Prosecutor may impeach the witness by asking the witness if they heard that the defendant was arrested for a crime involving honesty. In a civil case, character can only be used when it is an essential element of the case. This comes up in 3 scenarios. I. Negligent entrustment or hiring. 2. Defamation. And 3. Child custody. That is it. The way the 10-year rule is written, it serves to preserve convictions for impeachment, i.e., we have to see if 10 years or less have passed since the witness's conviction or release from confinement, whichever is later. So here, the 10-year clock starts running from the date of release from confinement, which was just 1 year ago. Under the FRE, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those elements are for the trier of fact alone. The best evidence rule only applies to tangible collections of data/information, e.g., writing, videos, photos, X-rays, computer drives, etc. In a civil trial, the jury must accept the judicial notice because it is conclusive in civil cases. One can impeach an impeaching witness. Learned treatise may be admissible as a basis for his opinion and as substantive evidence of the proper standard of care. Public records, such as vehicle registrations, are self-authenticating documents. Under FRE 104, c. the court must conduct any hearing on a preliminary question so that the jury cannot hear it if 1. The hearing involves the admissibility of a confession, 2. A defendant in a criminal case is a witness and so requests, or 3. Justice so requires. In deciding any preliminary question regarding whether a witness is qualified, a privilege exists, or evidence is admissible, the court is not bound by evidence rules except for privilege. The court may allow inquiry into additional matters on cross-examination that go beyond the subject matter of the direct examination. A judge must exclude the witness from the courtroom upon defendant's request unless witness is a party agent, a person who is essential to the presentation of a party's case, or statutorily authorized. Defendant may offer evidence of his character for peacefulness in his murder trial. A co-defendant that implicated the other defendant without testifying at trial violates the Confrontation Clause. A double-layer hearsay statement may be used to prove notice, but will still be hearsay if the first part is hearsay. A person perceiving something and is saying it out loud to another who says it to the 911, the 911 tape is a present-sense impression. Once a person has been formally charged, you can't place an informant in a cell to get the defendant to say something about the crime. Sixth Amendment violation. Evidence to prove identity. There must be unique facts to show the identity. The fact that the person making the business record had no personal knowledge of the underlying facts of the record is irrelevant for the business record exception. If the attorney-client communication is made to further what the client knew or should have known to be a crime or fraud, the communication will not be privileged. Generally, no leading questions are allowed on direct examination. Exceptions: questioning an adverse witness, a witness who needs help, or matters not in dispute. A sketch by the witness of the suspect, but the witness later dies. The sketch is inadmissible hearsay because the witness cannot be cross-examined about the sketch. Asking about witnesses' prior service on a jury that acquitted defendant of another criminal charge alerts the jury to the defendant's prior criminal trial, which is clearly prejudicial and violates FRE 403. The best evidence rule does not apply when reference to the contents of a writing are not facts at issue, collateral documents. Thus, the person may reference the contents of the document without providing the document itself. A business record may still be inadmissible if the report is untrustworthy because of an inherent bias, such as an employee involved in an accident also making the report. 10 minutes is not considered timely enough for present-sense impression. Opinion testimony of a non-expert who become familiar with the signature in preparation of trial cannot authenticate the signature and is inadmissible because he will be attempting to give an expert opinion when he is not an expert. By referring Peck to this journal in an interrogatory response, the defendant adopted the journal as their own statement of annual sales volume. A statement of fact of personal or family history contained in a family record, such as a Bible, genealogy, chart, engraving on a ring, inscription on a portrait, or engraving on an urn or burial marker, are an exception to hearsay. A statement that "it was my own fault, no one else to blame," is a statement against interest. A qualified expert need to offer treatise excerpts. Post-inconsistent statements may be used to impeach a witness. In order to forfeit either a hearsay objection or Confrontation Clause objection, a defendant must have engaged in wrongful conduct for the purpose of preventing the declarant from testifying. Drug activity can be a business activity for the business record exception. A trial judge possesses broad discretion to control the mode and order of examining witnesses and presenting evidence so as to make trial procedures effective for determining truth. The rules of evidence do not apply to grand jury proceedings. Erroneous denial of a peremptory challenge for cause does not warrant reversal if the prospective juror did not ultimately serve on the jury. Contracts. Warranty damages do not take the contract price into consideration, only the difference between value of accepted goods and value of conforming goods. A failure to perform a service contract by the due date is a minor breach if contract did not state time was of the essence. If the term assuring that the offer will be held open, UCC, is on a form supplied by the offeree, it must be separately signed by the offeror. In partial condemnation cases, the landlord-tenant relationship continues, as does the tenant's obligation to pay the entire rent for the remaining period of the lease. The tenant is, however, entitled to share in the condemnation award to the extent that the condemnation affected the tenant's rights under the lease. The statute of frauds requires that a contract in consideration of marriage must be evidenced by a writing to be enforceable. Whether a modification must be in writing to be enforceable depends on whether the entire contract price as modified is within the statute. Acceptance is an exception to the SF for goods over $500, but the acceptance is only valid to the extent of the amount accepted. If person accepts amount that is under the $500 SF, but the contract as a whole is over $500, the acceptance of some goods does not make the whole contract enforceable under the acceptance exception to SOF. Generally, the right to receive goods under a requirements contract is not assignable because the obligor's duties could change significantly. In fact, here, a significant change would seem possible because the large toy maker is a larger company than the small manufacturer, and its needs could be greater. However, the UCC allows the assignment of requirements contracts if the assignee acts in good faith not to alter the terms of the contract. The third-party beneficiary is subject to any defenses that the promisor could have used against the original promisee, even when the third-party beneficiary's rights have vested. Implied in every contract for sale by a merchant who deals in goods of the kind sold, there is a warranty that the goods are merchantable. To be merchantable, goods must be adequately contained, packaged, or labeled according to the contract and must conform to any promises or affirmations of fact made on the label. In cases where one party is aware of the ambiguity and the other party is not at the time of contracting, a contract will be enforced according to the intent of the party who is unaware of the ambiguity. Duties of unique skills typically cannot be delegated, but the other party may waive the non-delegability. Because a third-party beneficiary's rights are derivative, the promisor may raise any defense against the third-party beneficiary that it would have against the promisee. An option contract does not terminate by operation of law on the offeror's death. Payment of a smaller sum than due will not be sufficient consideration for a promise by a creditor to discharge a debt unless the consideration is in some way new or different or the amount of debt is subject to an honest dispute. And so the parties are giving up the right to litigate the amount which is sufficient to support a modification. A partial payment will suffice for an accord and satisfaction where there is a bona fide dispute as to the claim. A contract can be modified before or after the date of performance if the modification is supported by consideration. A court will not enforce a contract if its subject matter or consideration is illegal. It will leave the parties as it find them. If a merchant's offer indicated an offer amount for prompt acceptance, the offer does not constitute a firm offer that must be kept open for 3 months. A merchant's firm offer will be held open for a reasonable time and is not revocable. If the illegality is present at the time of the offer, there is no valid offer. If the illegality arises after the offer but before the acceptance, the illegality offers to revoke the offer. If the illegality arises after formation of a valid contract, it discharges the contract because performance has become impossible. An implied-in-fact contract is a contract formed by manifestations of assent other than written or oral language, i.e. by conduct. Even if there is no subjective meeting of the minds, the parties will be bound if their conduct appears to manifest a contractual intent. Physical incapacity by contract is not a defense of impossibility for services unless the services are unique. He could have delegated the services to not be in breach. Where the main purpose or leading object of the promisor is to secure an advantage or pecuniary benefit for himself, the contract is not within the statute of frauds, even if the effect is still to pay the debt of another. The parties to a contract may determine when vesting occurs, thus thwarting vesting based on reliance or bringing suit to enforce. An assignment does not need to be in writing nor require consideration. A third part may not raise a defense the assignor had against the creditor. A condition of a warranty that a good is merchantable does not materially change the offer for battle of the forms. If a buyer does not have full payment ready on delivery and the seller does not have the goods ready on delivery, each party's obligation is discharged. A party's failure to attempt to meet condition precedent is considered a breach of the duty of good faith implied in every contract and will be held to be in breach of the contract. 3 months is not the default time period that a firm offer will be held open. The default time period for a firm offer to be held open is a reasonable time, not exceeding 3 months. For an option contract, if the offeree gives rejection and the offeror takes steps in reliance, the offeree can no longer accept. If a contract says merely that a party cannot assign the contract, then this will be construed as prohibiting a delegation of duties only. In order to prohibit an assignment of rights, the contract would need to be explicit in prohibiting this. If the contract does not explicitly prohibit the assignment of rights, then an assignment of rights by a party will be valid. So, the permission of the other party is not necessary. When the rights on a contract have been assigned, the assignee can sue the obligor if the obligor fails to perform as promised. The language, "this offer can only be accepted by full performance," means that the offer can only be accepted by full performance, i.e., by completing application of the makeup. Remember that the offeror is master of his offer, i.e. unilateral contract. While it is true that the seller breached the contract, it may still cure as noted above. Installment contracts allow the seller to cure as a matter of right. However, in other contracts, the seller has a right to cure nonconforming goods in limited circumstances. Remember that a merchant's firm offer can exceed the reasonable time not to exceed 3 months if another date is stated in the firm offer that exceeds 3 months. For an accord and satisfaction to be valid, there must be a dispute present to trigger this form of settlement. An intended beneficiary will be named in the contract. An incidental beneficiary is one who is not named in the contract. At common law, the breaching party cannot recover the value of the benefit conferred. For a third-party beneficiary to have contract rights, i.e. the right to enforce the contract, the third-party beneficiary must have known of and relied upon the contract. It is okay that the third receive notice of the contract after it was formed. For a services contract, the rule is that a contract may be excused by contract modification that is fair and made in light of circumstances not anticipated by the parties when the original contract was made. While there is no general duty to disclose, affirmatively hiding material facts is fraudulent. Consideration is not required for a valid waiver of a condition. A plaintiff's expectation damages override a defendant's unjust enrichment damages if defendant is the one who breached the contract. An intended third-party beneficiary can acquire rights to the contract whether or not identified at the time of the contract is made. All that is needed is knowledge and reliance by the third party, which can come before or after contract formation. A payment by the obligor to the assignor is legally effective until the obligor is notified of the assignment. A party has a duty to mitigate his damages after the other party has repudiated the contract. He can only recover expectation damages. Consideration is not required for a valid assignment. Gratuitous assignments are freely revocable. If the obligor has no notice of the assignment to the assignee, payment to the assignor is legally effective. An output contract implies a good faith effort to sell the items being purchased. Under the statute of frauds, a surety must be in writing to be enforceable unless the primary purpose of the debt being guaranteed was to benefit the grantor. When there is a clear anticipatory repudiation, but since the non-repudiating party has already completed performance, he must wait for the remaining payments, i.e. remaining contract, to come due to recover them. A party to a contract whose performance is discharged by impossibility will be entitled to restitutionary remedies for any benefit conferred to the other party by part performance prior to the change in circumstance that made performance impossible. The freedom of contract may eliminate the mailbox rule. Money offered to settle a claim that one party knew had no legal basis, but filed it anyway, is not valid consideration because it is of no detriment to that party. Simultaneous offer to sell sent at the same time of an offer to buy will create a contract. An accord that references a previous settlement offer, only satisfaction of the terms of that previous offer will satisfy the accord. A promise to settle a good faith dispute over a debt can act as consideration, even for a modification. If a contract party fails to meet an express condition precedent, they cannot recover under breach of contract theory, but they can still recover under an unjust enrichment theory, even though the condition precedent failed. A series of unilateral contracts exists if the offer states, for each day's work actually performed. An assignor can be held liable for breach of contract when making an assignment in violation of the contract's assignment prohibition. The assignment will still be valid unless the assignee knew of the assignment prohibition. If there is a provision restricting the transfer of an interest in a leasehold to a third party, only the party protected by such provision, i.e. the landlord, may waive it. Violation of the contract's assignment prohibition, the assignment will still be valid unless the assignee knew of the assignment prohibition. Gratuitous assignments are generally revocable, but can become irrevocable if the assignment is accompanied by a symbolic document that is normally associated with the right or benefit being assigned. A party may waive the protection of a condition that has passed, but he does not waive the protection of a condition in the future, such as a condition on future payments. If two parties have two separate contracts and the seller repudiates one of the two contracts, the buyer can demand adequate assurances on the other contract. Goods are identified to the contract when the seller ships, marks, or otherwise designates them as goods to which the contract refers. SF exception for contracts that can't be performed within 1 year are judged from when the contract was formed, not when the offer was made. Under the rule of divisible contract, when performance under a contract can be divided into multiple tasks, each with a corresponding price that the other party must pay when the task is completed, one party's performance triggers the other party's duty to pay for it, even when the performing party breaches another part of the contract. Constitutional law. Ex post facto laws are laws that retroactively alter criminal laws. Contracts clause retroactively alters civil laws. For regs involving health, safety, and welfare, the court will presume that state police powers are not preempted unless that was the clear manifest purpose of Congress when it enacted its federal law. Where there exists a clear threat of prosecution if the person fails to comply with the statute, injury in fact is established for standing. Unless the law was motivated by a desire to interfere with religion, it can be applied to regulate the conduct of one whose religious beliefs conflict with the law. It can restrict the speech of a speaker because of an unruly audience only in the rare case when the police are absolutely unable to control the crowd. When a person claims that she is being punished for her religious beliefs, the court may consider whether the person challenging the law sincerely holds those beliefs. Regarding congressional districts, almost exact mathematical equality between the congressional districts within a state is required under the one person, one vote principle. However, neither federal nor state government is required to grant medical benefit payments for abortions, even if it grants benefits for childbirth services. The court has held that a state's failure to provide funding for a woman's abortion decision does not constitute interference with her constitutional right to make that decision. Privacy, rational basis applies. Although the right to vote is a fundamental right, laws prohibiting non-residents from voting, even though they pay taxes, are generally valid, provided that they meet the minimal scrutiny, or rational basis, standard. There are exceptions to the mootness doctrine. In a class action, it is not necessary that the suit by the named plaintiff be viable at all stages, as long as the claim is viable by some member of the class. The government cannot require you to respect the flag because the court has held that government employees cannot be required to show respect for the flag, as a person might refuse to salute the flag on religious grounds. United States Supreme Court has original jurisdiction in all cases affecting ambassadors, other public ministers, and consuls, and in which a state is a party. For all practical purposes, the power to regulate foreign commerce lies exclusively with Congress. Therefore, a state that adopts legislation requiring private vendors to favor United States products over foreign products, as the state did here, may be acting outside the scope of its powers. Property Clause, which gives Congress the power to make all needful rules and regulations respecting the territory or other property belonging to the United States. This power permits Congress to acquire and dispose of all kinds of property and to protect its property with a law such as the one here. A class action is not moot, and the class representative may continue to pursue it, even if the representative's own controversy has become moot, because the claims of others in the class are still viable. Regulation of foreign commerce is exclusively a federal power because of the need for the federal government to speak with one voice when regulating commercial relations with foreign governments. The existence of legitimate state interests underlying state legislation will not justify state regulation of foreign commerce. The Supreme Court has held that a government employee will have a property interest in continued employment only if the employee has a legitimate claim to, as opposed to a mere expectancy of, continued employment. To have such a claim, there must be a contract, clear practice, mutual understanding, etc., that the employee can be terminated only for cause. Congress has the power to create special courts under Article 1. The judges of those courts do not have protection of Article 3, such as life tenure and no reduction in salary. The court will likely not enter partial final judgment, piecemeal, if the party shows hardship coupled with potential undue burden on the appellate court. President does not have the power to pardon prisoners in violation of state law, only federal law. SCOTUS has proper jurisdiction in a suit between two states. Legislature may start a session with a prayer. Legislation must unequivocally, on its face, or as part of legislation history, an intention to fully preempt. Congress cannot appoint members of a commission that exercises enforcement powers. A SCOTUS decision is the law merely when there is absence of congressional action, federal statute, when Congress later enacts a statute that overrides the prior SCOTUS decision. A tax, even though enacted for a regulatory purpose instead of a revenue-raising purpose, can be upheld as necessary and proper exercise of Congress's power to tax. Indirect taxes by a state on the federal government or its property are permissible if they do not unreasonably burden the federal government. Congress may allow a state to adopt legislation that would otherwise be invalid as an unconstitutional burden on interstate commerce. SCOTUS will hear a case from a state court only if the state court judgment turned on federal grounds. The court will refuse jurisdiction if it finds adequate and independent non-federal grounds to support the state decision. The court hearing for the speeding tickets is a sufficient hearing when taking away a person's driver license. Merely granting public land to a private actor will not constitute state involvement. Federal violation of Equal Protection Clause falls under the Fifth Amendment of the Due Process Clause. Voting, running for office, and serving on a jury all meet the participating in self-government exception to the Equal Protection Clause. The test is rational basis. Lost profits does not require just compensation for a taking by the government, nor does equipment if it can reasonably resold. Even though state action may seem to not apply, a statute may apply state action-like conduct from the private actor. Foreign affairs decisions made by the president are not going to be heard in court as they are non-justiciable political questions. This includes recognition of tribes, recognition of other countries, and the decision to respond to an emergency attack or invade another country. The court will not hear the case. The city's public display of a Christmas tree does not violate the First Amendment. The Supreme Court has held that a Christmas tree is not a religious symbol. It has stated that although a Christmas tree once carried religious connotations, today Christmas trees are secular. In Lucia v. SEC 585 US___, 2018, the Supreme Court of the United States held that SEC administrative law judges are officers of the United States, and thus subject to the Appointments Clause. Under that clause, only the president and courts or heads of executive departments can appoint such officers. Congress has broad powers to tax and spend. Congress may tax and spend for the general welfare. It may not act for the general welfare. So if an MBE question states that Congress may do something pursuant to its power to act for the general welfare, it is wrong. This taxing and spending power is broad and does not have to be tied to an enumerated power. Even if it seems like Congress is using its power in a stupid way, i.e. to build a colony on Mars, it is still constitutional. The 11th Amendment prohibits a private individual from suing a state for money damages or injunctive relief in federal court, unless there is consent by the state or by Congress. This is called sovereign immunity. The rationale behind this rule is that states should not have cases that involve the state decided by federal courts. The states can decide these issues. Further, the state is not a party plaintiff, so the Supreme Court would not have original jurisdiction. The general rule is that racial classification that benefit minorities are permitted to remedy past discrimination, i.e. remedying past discrimination is a compelling government interest. But numerical set-asides require clear proof of past discrimination. A state may not impose liability for the accurate publication of information in the public record, but it may limit its own dissemination of information to the public. However, if Congress approves the state or local law, then it will be upheld even if it discriminates against out-of-staters or places an undue burden on interstate commerce. The rule is that states may not tax federal government activity, i.e., it is unconstitutional to pay a state tax out of the federal treasury. However, a non-discriminatory state income tax on an employee of the federal government does not impose a burden on the United States. The rule is that government restrictions on development must be justified by a benefit that is roughly proportionate to the burden imposed by the proposed development, or there will be a taking. If, however, the benefit is proportional to the burden, there is no regulatory taking. In both civil and criminal cases, the discriminatory use of peremptory challenges on the basis of gender by either the defense or the prosecution violates equal protection. The 10th Amendment states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. This does not give states plenary authority to construct their tax system in any manner they choose. The 15th Amendment protects eligible voters from discrimination in any state or federal election on the basis of race, color, or previous condition of servitude. A one-time grant of state monies to them is insufficient to warrant treating their actions as subject to the limitations of the 14th Amendment, state action. The state of Wonatal adopted a new, narrower sales tax exemption that only excluded certain religious texts from the state sales tax. This exemption clearly gives preferential state support to recognized religious faiths and, as such, it would violate the Establishment Clause of the First and 14th Amendments. When a case is tried to the court, the judge must find the facts specially and state the conclusions of law separately. The judge's summary announcement that judgment shall be entered for the manufacturer lacks the required findings and conclusions. A person has the right to have a jury selected from a fair cross-section of the community, not have the case be heard by a fair cross-section of the community. A cable television contract does not rise to the level of an entitlement under the Constitution. The government has no duty to provide facilities for abortion, nor does equipment if it can reasonably resold. The First and 14th Amendment to not privilege the press to broadcast a performer's act in its entirety without permission from the performer. The President must appoint all the members of a commission. A commission may investigate and make recommendations to Congress, but it cannot prosecute when some of the commission member were not appointed all by the President. The government may limit the persons who are allowed to vote in special purpose government unit if the unit will have a special impact on the enfranchised voters. The Supreme Court has only found such specialization for water storage districts. The Supreme Court has denied standing for general grievances, such as a plaintiff suing solely as a citizen or taxpayer interested in having the government obey the law. However, a taxpayer has standing and may challenge government expenditures pursuant to a federal statute as violating the Establishment Clause. This provision will likely foster excessive government entanglement with religion because it must be continually policed in order to ensure the funds are not going to teachers instructing in religious subjects. The Supreme Court has previously held that an oath to uphold and defend the state and federal constitution and oppose the overthrow of the government is permissible, i.e., a commitment to act according to constitutional processes. Congress has authority over the appellate jurisdiction of the Supreme Court, but not in a way that interferes with the establishment of a uniform body of federal constitutional law. 13th Amendment is used to prohibit private discrimination. Congress may create laws to ensure that the President can conduct foreign affairs without conflict through the necessary and proper clause. No limit exists on Congress's ability to delegate legislative power as long as intelligible standards are set and the power is not uniquely confined to Congress. The Supreme Court only has original jurisdiction in cases involving ambassadors or cases between states. Only appellate review in all other cases. States may not regulate federal activities in the absence of federal consent. Criminal law. Larceny. Once D takes property with the intent to permanently deprive, that's it, the crime has been committed, even if D changes his mind and decides to return property. An owner can commit burglary of her own structure if it is rented and used as a dwelling by someone else. Same for arson. Heart attack during felony murder is foreseeable. Watch out for a question that tests both the tort and criminal version of the crime. A felony of assault or battery that directly causes death would not be considered independent for felony murder. Mere knowledge that a crime may result from the aid provided is insufficient for accomplice liability, sales of ordinary goods at ordinary prices. For attempt crimes, focus on the elements of attempt and not the target crime, which is 1. Intent and 2. Overt act in furtherance of the crime. One who formed an intent to commit a crime and then drinks in order to work up his nerve to commit it cannot rely on the defense of intoxication, even though he may be too intoxicated to form that intent at the time he did the act. Police may use deadly force to prevent a getaway if the person poses a significant threat of death or serious bodily injury to others. It is possible to commit larceny of your own property if another person, such as a bailee, has a superior right to possession of a bailee. The doctrine of transferred intent does not apply to attempt. For burglary, the intent to commit a felony must exist at the time of the breaking and entering. Larceny requires that at the time of the taking, defendant intended to permanently deprive a person of her property. If the defendant wrongfully takes property without the intent to permanently deprive, e.g., without permission borrows an umbrella and later decides to keep the property, she is guilty of larceny when she decides to keep it. However, if the original taking was not wrongful, e.g., she took the umbrella thinking it was hers, and she later decides to keep it. It is not larceny. Solicitation and the completed crime merge, so the defendant could be convicted of one or the other, but not both. Further, solicitation merges with conspiracy, as explained above. Remember that even the slightest movement will satisfy this requirement of taking and carrying away for larceny. Remember that even a building is not typically used for a dwelling. If the building is used as a dwelling by the victim, it is sufficient to meet the element of a dwelling. Factual impossibility is not a defense to attempt. Can't be charged with selling cocaine, but can be for attempt to sell. An expert must not state the opinion of whether the defendant did or did not have the required mental state for the crime. That is for the trier of fact only. A defendant may be required to prove an affirmative defense, insanity, self-defense, entrapment, by preponderance of the evidence. Assault will merge into robbery if the robbery was committed with the threat that of immediate harm. Mistake of law will not allow you to escape liability for violating the law. If the person is not placed in fear, it is not robbery. Intent to restore substantially similar property is not a defense to embezzlement, money. Regulatory offenses are usually strict liability. You can be guilty of burglary and larceny. No merger. Transferred intent applies to intentional killings. Criminal procedure. If it appears to the judge that the defendant might be incompetent, the judge has a constitutional obligation to conduct further inquiry and determine whether in fact the defendant is incompetent. If the defendant is tried and convicted, but it later appears that he was incompetent to stand trial, the judge's failure to raise the issue or to request a determination of competency does not constitute a waiver of the competency issue. An undercover informer in the defendant's cell can question the defendant about anything without violating his Fifth Amendment right to counsel, and under the Sixth Amendment, the informer can question the defendant about any crime but the one with which he is charged. Therefore, if the cellmate informer questions the defendant and obtains information regarding a crime different from the one with which the defendant was charged, the questioning violates neither the Fifth nor the Sixth Amendment. The privilege against self-incrimination is waived by a defendant when she takes the witness stand, but only to the extent that she is subject to cross-examination. If the man refused to take the stand and subject himself to cross-examination, his confession was not properly admitted because it violated the woman's Confrontation Clause rights. Testimony obtained by a promise of immunity is by definition coerced and therefore involuntary. Thus, immunized testimony may not be used for impeachment of the defendant's testimony at trial. Miranda does not apply where interrogation is by an informant who the defendant does not know is working for the police, because the coercive atmosphere of police-dominated interrogation is not present. Because the man was not aware of the informant's status, the informant's conduct did not constitute a police interrogation. The Sixth Amendment right to counsel applies to all critical stages of a criminal prosecution after formal proceedings have begun, but does not apply in pre-charge custodial interrogations. Because this right is offense-specific, the fact that the right to counsel has attached for one charge does not bar questioning without counsel for an unrelated charge. When a person invokes Fifth Amendment right to counsel, all questioning must stop and cannot be reinitiated, even questioning for a separate crime. Absent exigent circumstances, the police executing an arrest warrant may not search for the subject of the warrant in the home of a third party without first obtaining a separate search warrant for the home. A search warrant does not authorize the police to search persons found on the premises who are not named in the warrant. Police still need probable cause to search the person present. After Miranda given, if D agrees to answer questions orally but requests presence of counsel before making written statements, D's oral statements are admissible. Jury instructions that place the burden of proving an element on the D is unconstitutional because the burden is on the state to prove each element. Standing to challenge Fourth Amendment search does not exist merely because a person will be harmed by introduction of the evidence seized during an illegal search of a third person's property. The defendant's own expectation of privacy must be violated. Merely being a passenger in someone else's car does not create a reasonable expectation of privacy with regard to a search of the car, and thus cannot be protected by fruit of the poisonous tree if search of the car was illegal. One may not raise a violation of another's Fourth Amendment rights at a suppression hearing. Open fields, even if fenced in, are not protected by the Fourth Amendment. Presence of counsel is a prerequisite to a post-charge lineup and attaches as soon as the accused is within sight of a potential identifying witness. Absent a clear intention, it is presumed that multiple punishments are not intended for offenses constituting the same crime under Blockberger. The police conduct here, telling the man that the woman had implicated him and then bugging the conversation, constitutes prohibited interrogation. No announcement needs to be made if the police reasonably suspect that knocking and announcing would be dangerous or futile or inhibit the investigation. Where a parent has general access to a room occupied by a son or daughter, the parent can give a valid consent to a general search of the room even if the son or daughter is an adult. A confession obtained in violation of Miranda, but otherwise voluntary, can be used for the limited purpose of impeaching a defendant who testifies at trial. Fifth Amendment right to remain silent does not afford a privilege to refuse to incriminate others. A confession obtained without Miranda warnings, as long as the failure to warn was not purposeful, may not be sufficient to justify excluding the non-testimonial fruits of the confession. The judge's failure to determine whether the woman understood her right to trial by jury indicates that her guilty plea does not satisfy the constitutional requirement that it be voluntary and intelligent. The judge should make sure that the defendant is informed of the nature of the charge to which the plea is offered, of the maximum possible penalty, that she has a right not to plead guilty, and that by pleading guilty she waives her right to a trial. Miranda violations can occur before a formal arrest. The test is whether the defendant was in custody at the time the statement was made. Commercial property owners in highly regulated industries have a lower expectation of privacy, which allows for warrantless inspection of those properties. The Supreme Court has held that the Fourth Amendment is not violated by a statute authorizing warrantless searches of a parolee's home, even absent probable cause, if a statute provides for such searches. A statement obtained in violation of the defendant's Sixth Amendment right to counsel may be used to impeach the defendant's contrary trial testimony. The Supreme Court has held that the court can require that the defendant prove the defense by clear and convincing evidence. The court can also place the burden on the defendant to prove the defense of mental illness by a preponderance of the evidence, which is a lesser burden of proof. The Supreme Court has held that 6-member juries must be unanimous. An arrest warrant would authorize police to enter the person's home if the police had reason to believe that the person was home at the time of the entry. However, physical evidence obtained as a result of an inadmissible confession will be admissible, so long as the confession is voluntary. The taint of an earlier unwarned confession is not transferred to a subsequent voluntary confession made after properly waiving Miranda rights. Remember, the exclusionary rule applies when there is a Fourth Amendment violation. It does not apply to physical fruits when there is a Fifth Amendment violation. Here, there is no unlawful search and seizure. Rather, the confession was obtained in an unlawful manner. An overnight guest generally does have standing to challenge a warrantless search of the place where the guest is staying. However, here the police entered the home upon the request of the homeowner, with the homeowner's assistance and consent, making a warrant unnecessary. Walking away from police in a high-crime area is not reasonable suspicion. Running away is. A criminal fugitive kidnapped in a foreign country and extradited against his will to the U.S. for trial cannot claim that his arrest violated the Fourth Amendment. The Supreme Court has ruled that a defendant convicted for felony murder cannot be sentenced to death if she neither took life, attempted to take life, nor intended to take life. A judge, however, may never grant a directed verdict for the prosecution in a criminal case, because doing so would violate the defendant's Sixth Amendment right to trial by jury. Only police coercion will cause a confession to be involuntary. There is no constitutional requirement that all no charges against the defendant be brought in the same prosecution. A corporation has no Fifth Amendment privilege, self-incrimination. A warrant is required to collect extensive historical site location data from a cell phone provider. The defendant loses his confrontation right by acting unruly and disruptive in court. The Cruel and Unusual Punishment Clause prohibits imposition of the death penalty on a person with a severe intellectual disability. A jury's conviction of a lesser charge constitutes an implied acquittal of a greater charge, thus barring retrial of the greater charge. Real property. A deed will not transfer an interest in land unless it has been delivered by the grantor and accepted by the grantee. Both the buyer and the seller generally are entitled to specific performance of a land sale contract. In general, a party who fails to tender performance on the closing date has a reasonable time after the closing date to tender performance and avoid breach. Not true if the contract says time is of the essence. A deed of trust is a security interest in land by which the debtor, i.e., the trustor, transfers title to the land to a third party, i.e., the trustee, such as the lender's lawyer or a title insurance company, acting on behalf of the lender, i.e., the beneficiary. Intermediate theory, under which legal title transfers from the mortgagor to the mortgagee on default. Because the son did not obtain the consent or joinder of the remainder man when he mortgaged the land, the mortgage attaches only to the life estate. Thus, the remainder men, the brother and sister, are not liable for the mortgage payments. When property is held in joint tenancy by 3 or more joint tenants, a conveyance by one of them destroys the joint tenancy only as to the conveyor's interest. The other joint tenants continue to hold in joint tenancy as between themselves. In a contract for the sale of real property, the seller of the land is entitled to use the proceeds of the sale to clear title if she can ensure that the purchaser will be protected. A profit is a non-possessory interest in land, allowing the grantee to enter on the land and remove resources of the land, in this case, fish and game. The profit can be conveyed from the original grantee to a third party. The holder of an easement has a right, even a duty, to make repairs. When a tenant continues in possession after the termination of her right to possession, the landlord has 2 choices of action. He may treat the holdover tenant as a trespasser and evict her under an unlawful detainer statute, or he may, in his sole discretion, bind the tenant to a new periodic tenancy, in which case the terms and conditions of the expired tenancy apply to the new tenancy unless the landlord notified the tenant before termination of the original tenancy that occupancy after termination will be at an increased rent. The rent increase must be reasonable. A chattel that has been annexed to real property is converted from personalty to realty, fixture. Built-in organ. The seller's purchase money mortgage will take priority over the third-party purchase money mortgage. In the case where a mortgage is modified, even PMEM, by agreement between the parties, any increase in the debt resulting from the modification will be subject to a junior lien, even if the original mortgage itself had priority over the junior lien. A debtor remains personally liable to pay for any deficiency arising from the foreclosure sale to foreclosing creditor and all junior creditors. Parole evidence generally will be admitted to show that a grantor did not intend to deliver a deed. Parole evidence is admissible to show oral conditions on the delivery of a deed if the deed was placed in escrow. A forged deed is void, and deeds that are void will be set aside by a court even if the property has passed to a bona fide purchaser. If a deed never was delivered, but the listed grantee discovers the deed and records it, the deed is void. A lien against one joint tenant's interest does not sever the joint tenancy until the lien holder proceeds to enforce it by foreclosure. At that point, the purchaser at the foreclosure sale will hold the property as a tenant in common with the other tenant, but will still have an undivided one-half interest in the property unless and until he brings an action to partition the estate. Partial actual eviction by the landlord terminates the tenant's obligation to pay rent for the entire premises. Partial eviction by a paramount title holder results in an apportionment of rent. The fact that an owner transfers title that includes a strip of land acquired by adverse possession that rests only on oral evidence, the owner's title will not be marketable. Regardless of any statute, a junior lien holder has the right to pay off the senior mortgage before the foreclosure sale to protect its interest. If the profit exists to serve the dominant estate, it is a profit appurtenant and can only be transferred with the dominant estate. If the profit does not exist to serve the dominant estate, it is a profit in gross and can be transferred separate from the dominant estate. If, prior to the termination of the original tenancy, the LL notifies the T that occupancy after termination will be at an increased rent, the T will be held to have acquiesced to the new terms if he does not surrender. In a commercial lease, if the original lease term was for a year or more, a year-to-year tenancy results. SF requires that any conveyance of an easement greater than 1 year must be in writing. An oral attempt to create an easement results in a revocable license. A neighbor's consent makes an easement by prescription impossible, no hostile element. When there is a mistake in the description of the property in the deed, physical description takes precedent over quantity description. LL are liable for latent defects even if they neither knew nor should have known of defect if the lease is for a short term and property is furnished. When T holds over, most courts will impose a month-to-month tenancy. Equipment installed for the purpose of trade by the T is removable if it is not an integral part of the premises and the T pays for any damage caused by the removal. Not subject to mortgage. Once you acquire land by adverse possession, you must get a court to recognize your ownership by bringing a quiet title action before you can sell and give marketable title to a buyer for the land. A landlord's promise in a lease to maintain the property does not terminate because the property is sold. Although no longer in privity of estate, the original landlord and tenant remain in privity of contract, and the original landlord remains liable on the covenant unless there is a novation. A covenant prohibiting assignment only does not prohibit subleasing and vice versa. Landowner may enjoin the excess use and possibly sue for damages if the land has been harmed from exceeding the scope of the easement. However, the easement does not terminate. The holder of the servient estate has the right to choose the location of an easement by necessity when there is 2 possible roads across his land. Dominant can't adversely possess the other road when given an easement already for original road. The key for determining the scope is the reasonable intent of the original parties, including the reasonable present and future needs of the dominant tenement. The benefit of an easement appurtenant passes with transfers of the benefited land, regardless of whether the easement is mentioned in the conveyance. All who possess or subsequently succeed to title to the dominant tenement are entitled to the benefit of the easement. If the buyer of land determines that the seller's title is unmarketable, the buyer must notify the seller and give a reasonable time to cure the defects. Easements are generally considered encumbrances that render title unmarketable, so if an easement is not provided for in the contract, it usually renders the seller's title unmarketable. There is an exception, however. A majority of courts have held that a beneficial easement that was visible or known to the buyer does not constitute an encumbrance. If an adverse possessor uses land in violation of a recorded real covenant for the limitations period, she takes title free of the real covenant. When a parcel of land is divided in 2 by a road, a possessor must meet COH elements for both parcels if she wants both. Yes, a junior mortgagee must be named as a party to a senior mortgagee's foreclosure action because it has the right to pay off the senior mortgage to avoid being wiped out by foreclosure. Failure to include a necessary party results in the preservation of that party's right to redeem despite foreclosure and sale. Real estate purchases involve a period of several months or years between the time the contract is signed and closing date. Seller is not required to provide marketable title until the closing date arrives. Same rules applies for an installment contract. The statute of limitations that determines the time period for adverse possession does not run against the holder of a future interest, e.g., a remainder, until that interest becomes possessory, because the holder of the future interest has no right to possession and thus no cause of action against a wrongful possessor until the prior present estate terminates. If the seller is unable to acquire title before closing, so that title remains unmarketable, the buyer can rescind, sue for damages caused by breach, or obtain specific performance with an abatement of the purchase price. If the assignee reassigns the leasehold interest, his privity of estate with the landlord ends, and he generally is not liable for the subsequent assignee's failure to pay rent in the absence of a specific promise to the landlord. However, even if the assignee made no promise to the landlord, but did promise the original tenant that he would pay all future rent, the landlord may sue the assignee as a third-party beneficiary of the promise to the original tenant. Title may be unmarketable where the owners of the present and future interests attempt to convey a fee-simple absolute title if the future interests are held by persons who are unborn or unascertainable. Improper recordation does not affect the rights of the original parties to the transaction. To be properly recorded, an instrument generally must be acknowledged before a notary public. Although an unacknowledged instrument does not impart constructive notice to subsequent purchasers, it has absolutely no effect on the validity of the easement as between the original parties. Title is unmarketable when the title has a possibility of reverter because of a fee simple determinable. Warranty deed can be enforced by any subsequent buyer. The fact that the friend is merely a donee rather than a bona fide purchaser does not mean that her recording has no effect. It is only the subsequent taker who has to be a bona fide purchaser rather than a donee to be protected by the recording statute. Foreclosure does not extinguish the underlying debt, i.e. second in priority. The debtor must still pay if there is a deficiency. Delivery of title to an escrow company is valid delivery of the deed. A conflict between a survey and the plat, the ground marked survey prevails. If the vendor of land cannot give marketable title, but the buyer wishes to proceed with the transaction, the buyer can usually obtain specific performance with an abatement of the purchase price in an amount representing the title defect. Only unconscionable conduct by the owner that substantially reduces the value of the land could possibly be enjoined by the person who would take the land should the current owner's estate terminate. Building a pool becomes a fixture and passes with the land. Common development scheme is sufficient for inquiry notice. To provide marketable title of land acquired by adverse possession, the seller must offer the buyer additional proof apart from oral evidence that the buyer can use to defend any lawsuit challenging title. Remember that recording statutes do not protect donees and creditors, only bona fide purchasers. Mortgagees for value are treated as purchasers under the recording statutes. A third party may give a mortgage of their property for security of a loan to another person. The bank can foreclose on that third party's property associated with the security mortgage provided. Remember that conveyance of real property must be in writing. If a testator wills my estate to X, X will also have the reverter right to the testator's estate. A will trumps any laws of intestate succession. Whether or not the recipient of the warranty deed recorded her interest does not bear upon an estoppel by deed analysis. An absolute restraint on the alienation of property is void. A restraint for a limited time and for a limited purpose may be upheld. One type of invalid restraint on alienation is a forfeiture restraint, which states that one forfeits one's interest if one attempts to transfer the estate and the estate returns to the grantor or his heirs. If a restraint is invalid, it will be stricken and the grant will be read as though the restraint did not exist, but the rest of the conveyance language will remain. However, none of this is relevant because another statute of the jurisdiction provides, any judgment properly filed shall, for 10 years from filing, be a lien on the real property then owned or subsequently acquired by any person against who the judgment is rendered. Since Corp had already conveyed Blackacre to Barbara, it was not, then owned, when George filed his judgment against Corp. As such, the court should decide for Barbara because Barbara was the owner of Blackacre when George filed his judgment against Corp. Brenda would lose this action because there has been no redemption from the mortgage. Brenda has the right to redeem the property from the mortgagee by paying the full amount due, including interest and attorney fees. Since Brenda only tendered half of the amount due, she has not redeemed the property and, as such, would lose in her action to quiet title. The life tenant must pay taxes on the land to the extent of the income or profits derived from the land or, if none, to the extent of the reasonable rental value of the land. In this case, lots 1 and 2 were vacant and unproductive. As such, Lena had no obligation to pay the taxes on these lots. A wild deed does not provide record notice to later purchasers of the property because subsequent bona fide purchasers cannot reasonably be expected to locate the deed while investigating the chain of title to the property. A void deed will be set aside even if the property has passed to a bona fide purchaser. Void deeds are forged deeds, deeds that were never delivered and deeds with fraud in factum. As such, Charlie would not be able to unilaterally change the location of this easement based on the defense that his proposed solution is reasonable. Under the covenant for warranty, grantor warrants that she will defend against lawful claims and that grantor will compensate grantee for any loss that grantee may sustain by. While attachment objectively shows the intent to improve the property, any express agreement between the landlord and the tenant will control whether or not other personal. If a buyer signs a sale contract and then records it, he becomes the equitable owner. It also provides notice preventing a judgment lien from creating an encumbrance, making the title still marketable. If a tenant in common gives up his possession of the land, he still is a tenant in common. One tenant in common cannot solely bind another tenant in common to a boundary line agreement. Delivery of the deed is presumed from recording the deed. A landlord-tenant relationship may not be considered hostile for purposes of adverse possession. If a person enters into a sales contract for the sale to land that they have no title to, if they acquire title before closing, they must close at closing. Tenant's lien against H's joint tenancy terminates if H dies and the property interest passes all to W. Nothing is left for the lien to attach to. A life tenant must pay the mortgage interest on the land to the extent of the income or profits derived from the land, if none, to the extent of the reasonable rental value of the land. Future interest holders are responsible for the principal portion of the mortgage payments. A mortgagee may use proceeds to pay off a senior mortgage and be substituted into his priority position. Warranty deed to all the leaders of X church in Y county or similar does not adequately identify the grantees as required. Remember that a remainder may be divisible, descendable, and alienable. Under common law, dedication states that when an owner of land voluntarily donates land to the public, and this donation is accepted, ownership is thereby transferred to the governing body. A life tenant has a duty not to consume or exploit the natural resources of the land unless 1. Prior use, 2. Reasonable repairs and maintenance, 3. Expressly authorized by the grantor, or 4. Normal use of the land. The life tenant is required to pay the interest on the mortgage. The person holding the life estate's future interest is responsible for the mortgage's principal. 2 adverse possessors will become tenants in common. Each co-tenant is responsible for their share of the mortgage payment. Wills.